Good afternoon. I'm David Horrigan, eDiscovery Counsel and Legal Content Director at Kcura Relativity. I'm here with Martin Audet, techno-lawyer extraordinaire, and I had the pleasure of speaking on a panel with Martin earlier today about the early meet and confer, where we put together a checklist. Martin, what was your biggest takeaway from our session?
And by the way, you did a great job.
As did you. Thank you very much.
I appreciated that. It's a lot of good ideas. That was a good panel. I think the takeaway was a lot of people discussing the points, but when to start thinking about that is way before, early. You know, we keep talking about, especially here being at the EDRM University of Florida conference, the EDRM model has been such a prevalent piece, and everyone talks about, I'm on the right side, I'm doing this part, and using that. But I think that the one takeaway I got is always start looking to the left of the EDRM model for any of this planning, because it has to be done early on. When the other two panels that preceded us talking about the collection and the preservation, it's really this iterative process if we look at the model, you know, with what we were discussing, and when you finally have to bring it all together, and then you're going to, all of a sudden now, things are filed, we're going to have that meeting, and as part of Rule 16, we have to come up with a discovery plan,
Sure.
right? So these are the things that I think a lot of people are not prepared for, at least a lot of the people I've been dealing with. Maybe I've been living in some different backwater, but a lot of the attorneys—
I don't think you are.
But a lot of the attorneys that, you know, and they're all well-meaning, but I think that we need to just have more of these type of educational sessions. That's what I got from the takeaway from our session. Everyone really talking about the different stories, and for me it was prepare, and be ready, you know, especially the left side in that session.
Makes perfect sense. You know, in addition to proportionality and the whole idea of sanctions, and we could speak for hours on that
Yes,
one,
we could.
cooperation in e-discovery has been a big topic since the 2015 amendments to the Federal Rules of Civil Procedure. Taking up that cooperation, and it was one of our points on the checklist.
Yes.
What are you seeing since the change in the rules? Do you think that there is more cooperation? Two-part question here for you.
Yes.
Are you seeing more cooperation? And part two is, if you don't get that cooperation, what do you do?
It's, you know, I guess it's just in the nature of what I've been doing as a consultant for the last few years. I don't see as much of that. So the cooperation with the different groups, especially internally, I guess it depends on who the audience is. When we're dealing with inside counsel, outside counsel, are we dealing with the compliance groups? Are we dealing, you know, again, always within context, that I think people are much more aware of it. They're a lot more open. In my own consulting groups that I've been dealing with, there's been definitely, I see more cooperation, because they're a lot more open and they're not sure. They're not really sure what to do, and they're testing the waters. On a very small basis, I've also seen some of the attorneys that are just...
So what do you do when that happens?
That, I don't have enough experience to talk about that. Yeah. We could talk about that for hours. About,
Sure.
you know, when some of the points I made earlier were, if they are being belligerent, or they're not open to it, or they're not open to getting educated as part of their requirements and the competence, right? The ethical requirements for them, you just start asking questions. And I think the judge made a great point too, and that I think that we all believed in, is that will show itself, right? I mean, that will come out, that will bubble up, and he's, you know, whatever the issues are, always kind of come to the surface. So ask the questions. I always ask the questions. I always try to be absolutely beyond reproach, or at least we talk with the clients, because I have not actually practiced. I've been like consulting with it, so I'm not the one who's in the in the courtroom or in the conferences. I'm on the side. A lot of times I'll go to the conferences as part of the discussions, but I'm not the attorney of record on it. So
yeah,
I'm talking about a little bit on the side.
I hear you. You are an attorney, and so that gives you some special insight.
It's a lot of fun with that too.
Yeah, imagine, because you are more technically competent than probably 98% of the attorneys out there. Are you seeing some improvement in technological competence among lawyers?
Not at the rate at which I had hoped from in the last, you know, I did my first, I'll call them meet and confer, but our first, with opposing counsel in 1995, our first meeting discussing emails with the CompuServe and Prodigy email. That was in Windows 95 had just come out, and those issues were coming up, and I feel that I've been kind of stuck in a certain I guess, time bubble.
Sure.
That even though like now we're in Windows 10, and maybe we have different types of emails, and those companies are gone, a lot of the discussions are the same. The deer in the headlights, I think that everyone was joking around about that. You get a lot, ask questions and say, all right, well, this is what we're looking at, this is the scope we're looking at, these are where the data centers are, and a lot of times people are just not ready to discuss that. And they're like, and I just find that disturbing still.
Yeah.
So I think it's still going slow.
You know, you mentioned that email, and that's a great segue into my last question for you. We've heard about all the alternative data sources, and we've been hearing people say for years, email is dead, and we've also heard keyword searching is dead. We just had a session where I got to live tweet some of your great quotes, and
appreciate it.
Clearly,
hopefully,
keyword searching, yeah, they're great. Keyword searching clearly is not dead, but you made the comment, keywords don't occur in a vacuum. Can you explain that a little bit for us?
Again, with a lot of the consulting I've done, a lot of the groups, the attorneys, they sit in a room and they think, okay, well, these are our claims and defenses. This is a request for whatever they're looking at, and they're coming up with their ideas. And then they say, okay, well, I think this would be a good search term, and they write it down on a piece of paper, and then they send it off to the vendor or someone else in the firm. And I see this at larger firms, maybe multi-city firms, and they have a centralized spot, in New York or center of the United States, wherever they're at. But the attorneys never really engage with the people who are doing the work. I see this in government a lot, between the people who are doing the investigations and then the attorneys, or the people who are running, or the paralegals, or however you want to call it. They're not actually digging in. And I just used the example on that panel that when I first started practicing, when we all started practicing, it was a banker's box.
Yeah,
the real thing, right? And everyone used to get in. I mean, the partner at my first law firm, a litigation firm in Chicago where I started practicing, he would come in and he was the partner. We would start rifling through to see what we had. He was informing himself, and we were all informing himself. We didn't get deep into it, but we saw what we had. Or if we were at the warehouse, at least we'd go through each of the boxes. I'm just using this as an example.
Right, sure.
But that has been lost with this, because this, I call it the electronic banker's box. Now, with these different tools, it's our electronic banker's box. And I think a lot of these people are just scared. I don't know what it is. I just use an example of when I was just down with another group, and I said, you have to look at this stuff, let's just do, and she said, and this is a fairly young attorney, but she still said, I don't like looking at it on the screen, so let's just run the search terms.
The tactile feel of actually seeing what the people do.
Exactly, so I understand it, but at the same time, it's also causing a problem with these people not wanting to dig in, and that was the point. So when I said about the keywords being in a vacuum, from earlier, was that there's so many different criteria that you can use. A lot of people have said keywords, they're terrible because you don't get what you want. And I think that we just made the point that a lot of the underlying technologies, the underlying basis, and the expectation of the people who are sitting in that room, who don't look at it and don't test, is unrealistic. So yeah, if I just scribble down some things and say, okay, that's what we're going to put into review, that's unrealistic, and a lot of people are still doing that.
Gotcha. Well, Martin Audet, thank you very much for taking us to the banker's box. And after the conference is over, I'll share with you some horror stories about being trapped in an elevator with banker's boxes.
Oh, that'll be fun.
Martin, thanks for taking us from the banker's box to keyword searching, to the modern technologies we're using today. Thanks for being here. On behalf of the University of Florida, I'm David Horrigan with K-Cura Relativity. Thanks for being here, and enjoy the rest of the conference. Thank you.